afternoon, first of all. Welcome. I want to say welcome to the people who just joined us, and thank you for your interest for the people who are with us since morning. So today we're going to have our special session, a conversation with Ms. Carolyn Lamm, a unique career in international arbitration. My name is Aidana Rasova, and I'm the junior associate here at the AFC Gordon International Arbitration Center, as well as the chairman of the ICVIS Alumni Association here. So we are incredibly honored to have Ms. Carolyn Lamm with us today, a name synonymous with excellence in international arbitration. Carolyn is a partner and former senior partner at the White & Case, Washington, D.C., at the world's leading law firm, where she has successfully led high-stake cases, but representing both sovereign states and multinational corporations. Her contributions to the law as a profession are, in general, profound, from her leadership roles in significant cases under ICSID and NAFTA, to her advisory work within American Law Institute and the International Council for Commercial Arbitration. In addition to her legal practice, Carolyn has served as the president of American Bar Association and continues to be a leading voice in the global legal community. Her commitment to advancement of international arbitration can be seen not only in her professional work, but also her dedication for educating next generation of young lawyers at the University of Miami Law School. So today we have rare opportunity to hear her insights on development, history of international arbitration, the role of women in international arbitration, and in general the critical skills needed for the success in legal profession. So today's session will begin with the initial conversation with Ms. Carolyn Lamm and myself, and will be followed by the questions from the audience. Carolyn, we are very delighted to have you here with us. Welcome.
Thank you. Thank you so much, and good afternoon to you. And I see you had a very stimulating program, so I'm delighted to be with you for this phase of it.
Thank you very much, Carolyn. So to start, I want to look back at the beginning of your career. And my first question would be, what inspired you to become a lawyer and arbitrator, or maybe who influenced your decision to become an arbitrator and lawyer?
You know, women around that were role models at the time, and I decided to go to law school, and at that time there were only 10 women in my class out of 376. So it was a very different time, I would say. But in law school, I loved the international law courses and took all of them, and all the comparative law and civil law. And I chaired the international committee and did a number of things, international moot court, etc., and really just gravitated in that area. I went immediately to the U.S. Department of Justice under the honors program for new lawyers as a trial lawyer in the civil division, and at that point learned to try cases for a few years and became assistant director of commercial litigation in the department. But I learned advocacy, and the way you learn advocacy, of course, is on your feet. You've got to learn by doing, I think, and really have the responsibility yourself for developing the facts, developing the law you're going to argue, etc. And that really prompted me then to look for something more internationally connected, although at Justice I still sought out every international case I could find, and really developed as an advocate there, because you learn argument, you learn at oral advocacy, written advocacy, etc. But I sought out, leaving justice, I sought out an international law firm and went to White and Case. But that was in February of 1980, and a lot of international arbitration was really beginning. The very second case ever at ICSID, I started working on AMCO Asia as a very, as a young associate, and really developed from there. At White and Case, I was able to do almost exclusively international disputes, either in court or in arbitration. And many people inspired me and continue to. Florentino Feliciano, of course, from the Philippines, was extraordinary, and I met him first on an annulment panel in the AMCO Asia case, but then sat with him as an arbitrator in the ADF versus US case, and was co-counsel with him in the Fraport v. Philippines case. I worked with him tremendously. He was a great scholar, a great lawyer, and a great advocate. Of course, Professor Michael Reisman at Yale, who's a fabulous intellect, a fabulous lawyer and advocate, and Aaron Brackus, the founder, basically, the leading light at ICSID. And so I really had, many at that time who helped me form who I became in my career.
Thank you very much for your answer, Carolyn. Given your extensive experience, as you said, you've worked in many jurisdictions, and I know that my next question might lead to a long, detailed discussion, but I would like to know, and I think the audience would appreciate, if you could share with us your overall sense on the history, development, and significance of international arbitration in the 21st century.
Well, as global business and cross-border transactions and infrastructure development grew, a method of dispute resolution had to grow. And you couldn't, for any of the big international investors or contractors, they would not rely on the national courts of wherever they were going. And I wouldn't suggest that anyone rely on the national courts even in the US. There's an inherent bias, so to speak, and if you're investing a lot, trading a lot, you really need to be assured of some method of dispute resolution. And I'd say in the earliest days, everything was espoused by the state, by your home country state, and it was settled state to state. And there was gun battle diplomacy. Well, that gave way because it really, everything then became infused with what political chips the home state would want to spend to solve an investor or contractor's issues. And ICSID grew up, investor state arbitration grew up, as did commercial arbitration. So you saw the emergence, certainly in the 70s, 80s, of both the international regimes at ICSID, at ICC, at SEAC, and now it's become the method of dispute resolution for cross-border transactions, of course, and international arbitration is a must in today's world. And many of the regional centers have developed. And they're very important to offering an alternative option to many of the other institutions and fora. And of course, the supporting courts are very important, and the supporting arbitration laws are very important. all of which have continued to develop. So, in the early days, we saw proliferation of treaties, when the BITs emerged, and proliferation of contract clauses that selected various different arbitral fora, and they continue to. And they're, very important for multinational, multilateral business. There's really no other way to provide the assurance to someone who's investing or trading in large amounts of money to that if there is a dispute, it can be resolved, and it can be resolved without a home court bias.
Thank you very much, Carolyn. Talking about the arbitration in regions and narrowing down now, you have a considerable experience in arbitration in Central Asia. My next question would be, if I may ask, could you share your observations on evolution of arbitration in Central Asia and your overall impression of it?
Yeah, I think arbitration has been central to a lot of what we've seen as very significant development in cross-border business, cross-border infrastructure development in Central Asia. With all of the investors, certainly, and I'm chairman of the American Uzbek Chamber, and I'm very familiar with what the investors and what those that are trading with at least Uzbekistan think of when they're deciding, when they're making investment decisions. They're thinking about, where am I going to go if a dispute arises, particularly in jurisdictions, if they're coming from the US or UK or wherever, that they're not as familiar with. And, the laws, certainly in Central Asia, have been evolving, as has the economies. I think, and each is evolving at a very different rate because of the resources they have, because of the sophistication of the legal systems, etc. So we've seen a lot of interest in Central Asia, and we've seen that investors and business people are very much attracted. And most of the Central Asian jurisdictions have embraced international arbitration, and they do either offer ICSID or ICC or SIAC, and now, the Tashkent Center, the Kazakh system. So there are quite a few options for investors, and they are of fundamental significance. And they've developed, and they are now developing really strong regional centers.
Thank you very much, Carolyn. Before I move to my next question, I'll kindly ask one more time to mute your phone so everyone can enjoy our conversation. Thank you very much for your cooperation one more time. Carolyn, coming back to your career path, and that's truly inspiring. Can you tell us about your first appointment as an arbitrator? How did that opportunity come about in your view, and how has the role of an arbitrator in international arbitration changed since then?
Well, my first appointment was in, what would be a comparable local center in the AAA and ICDR. While they were international disputes, they were often US-Canada, US-Mexico, and smaller cases. And you really learn, as I said with advocacy, you learn by doing. Of course, I'd studied quite a bit in terms of arbitral decision making, the rules, the law. I've advocated under all of the national systems when it's relevant to the case I was handling as an advocate. So I was really familiar with a lot of the procedure and arbitral decision making because I'd been trying to persuade and influence for years before I got my first appointment. But I started really being appointed in cases for AAA and ICDR. And from that, I then was appointed first by the United States as an arbitrator on the US list for ICSID, and then by Uzbekistan after I finished my first term. Uzbekistan has now appointed me for 2 terms on the Uzbek list at the ICSID. You know, it's just each state gets to appoint 3 or 4 people as arbitrators or conciliators. And I'm on several others, but a lot of the appointments now come from parties rather than institutions.
That's very interesting. Thank you for sharing that. And we talked a lot about your achievements throughout your career. And my next question, I think, would be very relevant, considering that we are at the event Women in Arbitration, and I would really like to know what have you observed about the role and influence of women in international arbitration over the years, and how has the landscape changed for women in particular?
Well, I think women are playing a greater and greater part in international arbitration as advocates and as arbitrators. And that's very important. I currently chair, as part of the ICA, the Inclusion Committee, the task force on cross-institutional gender diversity in arbitral proceedings. And that has produced now 2 reports you could get on Kluwer. One is from 2020, one is from 2022. And we, on this task force, have all of the major arbitral institutions represented. And we examine the gender diversity in terms of arbitral appointments and leads in arbitral cases. And there's a very clear indication, I'd say, between 1990 and today, of a significant upward trend of women sitting on tribunals and being first chairs or on the teams in big arbitrations. And the study demonstrates that in the 90s, women represented maybe 2 to 5%, but it has emerged up to about 20 to 25%. Some institutions are better than others when you're looking at the institutional appointments in terms of how many women they appoint. Institutions don't get to appoint that many because most of the appointments are by the parties or by agreement of the arbitrators. Our task force report on gender studies both. Those appointed by the institutions, those appointed by the parties, etc. So I've looked at this in a very granular way, and I can tell you women are doing better. Are they where they should be? No. In most jurisdictions, women are half of the profession or close to half of the profession. And I think that women should, in fact, be more involved as they are, sitting as arbitrators and leading arbitral disputes. But I'd say there's great improvement from where it started, and I hope there will continue to be. We're doing an update to the report. The last one was in 2022, and we're now doing it, so it should be out in 2025, but it'll be a report on the data from up through 2024. So you'll be able to see the trends in a very data-driven way of the advancement of women in key positions in international arbitration in that report. It's all on Kluwer or on the ICA website, and you can look at the task force reports. But I think they're very, very good in terms of having accumulated all the actual data.
Thank you very much. I asked this question because women are known for being multitaskers, and you've balanced roles as a lawyer, arbitrator, and academic throughout your career. My next question, if I may to ask, how have these different roles contributed to your overall success and influenced your approach to international arbitration?
You know, I think all are very important. You know, each dimension contributes something else to the way you approach analysis, problems, and you grow as a lawyer or as an arbitrator. And so, you know, they help if you achieve with excellence in each of the roles. Certainly you build a reputation, you build credibility, you build recognition. In-court work is helpful. It demonstrates the ability to handle evidence and make arguments, etc. And certainly in the US, that's public. Arbitrations are not, so the only thing that you get from an arbitration is maybe an award published. But you don't have everything in between. And, you know, I think it also, in all of the roles, improve you. Even as an academic, it helps because you think through in a very analytical way many of the legal issues. So you have an understanding of what you're trying to prove, how you're trying to prove it, what are the variable things you can argue. So you bring a lot more to the task. And I must say, I always teach. I teach at Miami investment arbitration. I teach many of my cases, and I learn tremendously from my students because you hear the different ways they may have approached something and why, and you know, they are all very good and very stimulating, and I think that's important.
Thank you, Carolyn. As you mentioned about your students and about your training for the next generation of young lawyers, and as someone who has achieved so much in this profession, what do you believe are the most critical skills that young lawyers and aspiring arbitrators should develop to succeed in today's legal landscape?
Well, I guess everyone starts with advocacy, written and oral. You must be a good, clear writer and communicator in order to, whether it's as an advocate or on a tribunal, persuade your point of view. And so really a clarity in terms of advocacy and developing your legal analysis and legal thought and knowing how to handle evidence. That's, you know, of critical importance. Certainly working with evidence, no matter in what role, whether it's as an advocate, as a lawyer, you've got to learn how to use it, how to build your case, and how to use it to demonstrate the legal theory that you're saying should win your position. And it sounds easy, but it's not. It takes a long time to develop. And I think certainly, even if in your current practice you don't have all the opportunities, write some articles that demonstrate reasoning and analysis and get them published. It's not terribly difficult. And speaking at conferences to build networks, build reputations, etc. And I'm on an advisory board for the Rising Young Arbitrators, and they really learn from experienced arbitrators and learn from each other and share a lot of the important skills and what they're doing to develop them. So, there are a lot of things around that you can look to develop yourself. And in my task force report on gender diversity and arbitration, the ICA report, there is a roadmap. It's a roadmap for young lawyers who want to develop in this field and as arbitrators.
Thank you very much, Carolyn. Today we have a lot of young lawyers who aspire to become a professional just like yourself. And I would like to mention that IC actually offers a lot of internships and training programs to train those soft and hard skills needed for to become a professional and to excel as a lawyer. So we are very welcome to have you and see you there. And coming to the end of our session, I would like to address my last question. What advice would you give to young women who aspire to become leaders in law and arbitration following your footsteps?
Well, I think developing your reputation for whatever you do with excellence. And you know what? I hate to say it, but I think women have to almost be better than men, because people start assessing you and thinking, well, maybe she's not so good in this area or something. So you've really got to prove that you can excel, you can do it, and you're not going to be terribly distracted by anything from doing what you need to do to prevail in a case. You have to develop a reputation, certainly, for integrity. People need to rely on you and know that, you might be resourceful, you might be many things, but you're going to be very ethical and reliable as a professional. If you're sitting as an arbitrator and you get your first appointments, it's very important to do them with devoted excellence. You have to demonstrate you've read everything, you've thought about everything. There can be reasonable differences of opinion, but they shouldn't be prompted by not having done what you should do in terms of looking at the evidence and looking at the legal arguments that the parties have presented. I always pose the questions that are troubling the tribunal. If I'm sitting on a tribunal, I think it's my job to ask the parties whatever the hard questions are that the tribunal is struggling with, because you want to give both of them an equal opportunity to address them and give you the best evidence you can get, the best legal argument you can get, or say, don't think about it, it's absurd. I don't know. But you need to give the parties the opportunity, and they have to feel that you're someone that's interested in assuring they have due process. A lot of times I think parties are terribly disappointed in tribunals who don't let them feel they've been heard. And so that it's an important dimension of developing yourself as an arbitrator. And I think doing a number of things where you can demonstrate your excellence. Arbitral Women, of course, one of the sponsors of your program, is a tremendous resource, and many of the other groups are tremendous resources. In my task force report, we actually had interviews of 50 women arbitrators who were prominent and asked them these questions. And you'll see reflected in the report the various recommendations and approaches that many different women arbitrators recommend, but they all kind of boil down to the same thing, striving for excellence, having integrity in all that you do as a lawyer, as an advocate, as an arbitrator.
Thank you very much, Carolyn. With your permission, now I'd like to open the floor to the questions from the audience.
Sure.
Okay, thank you. Dear audience, so please raise your hands if you have a questions. I'll ask our team to assist you with the microphones. When you'll get a microphone, please introduce yourselves, your names, the organization that you're representing, and then please address one question at a time so we can accommodate as many questions as possible. Thank you. So please, who have a question, you may raise your hand.
Hello, Ms. Lamm. Thanks for such a wonderful session. My name is Mirai, and I am a junior associate at the AFC Court and International Arbitration Center. And my question is, recently we have seen an increasing number of regional arbitration centers. And with this decentralization trend, what do you think this will impact for the future global arbitration landscape? Thank you.
Thank you. Good question. There has been a significant emergence of these regional centers. And I think what we've seen to date is they're being incorporated into contracts, but some contracts, usually local or maybe with one host state entity, a Uzbek entity, for instance, and a Russian entity. But it's rare that I've seen them used in big contracts and cross-border deals. I think they will emerge that way as they begin to develop and build a real reliance on the people who serve as arbitrators for the courts, etc. But it's going to take some time, I think, for investors and international business people to have confidence in the systems, the rules, the enforcement, etc.
Thank you, Carolyn. Next question, please.
Ms. Lamm, my name is Lydia, and I'm a legal student at Maksut Narikbayev University. And my question concerns the culture. Given your experience, could you please share the information of your experience? How important is cultural awareness in international arbitration? And maybe you have a case where culture awareness was very, very significant. Thank you.
I do think cultural awareness is very important. You need, and I would go beyond just cultural awareness. I think both as an arbitrator, as a lawyer, when you're representing international clients. You need to know and understand where they're coming from, how they're making decisions, what they value, and it's the function of many things. One, obviously, is the culture, the legal system, the economy, the religion. And you just need to understand the variables of each and respect them so that you can understand how are they deciding things and where are they placing values and why. A lot of that is very, of course, informative and soft guidance. It's not in black letter law, but I think you need to appreciate, understand, and respect where the parties in front of you are coming from and why.
Thank you very much for your answer. Next question. Please.
Добрый день, мисс Лэм. Меня зовут Ботагоза Алпыспаева, я адвокат Алматинской городской коллегии адвокатов. Такой вопрос у меня. Исходя из вашего опыта, в чем преимущество женщины в праве, ну и в целом в юрбизнесе, в арбитраже и так далее?
So Carolyn, we have a question from Ms. Botagos. She's an advocate in Almaty Chambers of Advocates. So her question is, from your experience, what is the advantages of women as a litigator, as an advocate, an arbitrator, and in general in legal field?
Well, I think diverse tribunals and diverse legal teams bring a better approach and thinking to any problem because you sometimes value different things, think about different things, and the collaborative effort is important. I also think women are often more detail-oriented, are more considerate of others, etc. And I don't know if that is a legitimate observation, but it's just what I've experienced. It's more anecdotal than scientifically supported. But I think a collaborative effort by a diverse team and a diverse tribunal produces better results.
Thank you very much, Carolyn. Спасибо большое за вопрос. Next question, please.
Hello, my name is Sole. I am from Ur Kazakhstan Audit Company. Carolyn, we are all here women, and we have kids, families, and everyone has some issues during their career. So, do you have any? Did you experience any challenge in the past? How you deal with this? You choose career or family, or which kind of advice you can give to the younger generation? Thank you.
You know, that is a challenge, but one of the greatest things in life, in my view, are my children and being a great mother and a great wife. So I think it's very important to be able to find a balance in what you do and how you approach things. It takes a lot of help and support, certainly from your spouse and certainly from nannies or people that you hire to help you, as well as your family. So, you get through it all by juggling everything. And if it means coming home early to be with your kids, but then you go back to work until later in the night, that's what you do in order to do both. It's exceedingly difficult, of course, to juggle everything. But you must find a way that you personally are comfortable doing that.
Thank you very much for your answer, Carolyn. Any other questions from the audience? Great. Oh, okay, we have a question here. Mhm.
My name is Laura. Dear Carolyn, thank you very much for your session. And you look gorgeous. This is my compliment. Thank you very much. You are a lawyer in America, and I just maybe not concerned our topic session. Just question is about American movies about lawyers. If it is possible to ask you, we watch a lot of movies about Suits. Maybe you heard about this movie, or Ellie McBeal, something so, etc. And my question is it a real picture or a real, how to say, mirror of the lawyers in America? So I mean the court, the lawyers, the advocates, and the judges in this court system. Is it real, true, like in movies, or it's just like, how to say, movie? Sorry, if it's not concerned to the topic.
Yeah, I spend so much time working, I'm not sure I've ever watched a full episode of Suits. But, the things that I've seen, certainly, it is formed the same way with advocacy and standing up to argue. And, it is a common law system. And you do, the judges don't do the inquiries, the lawyers do. The lawyers present the cases and the witnesses. The lawyers argue the facts and the law to the judge. And if there's a jury involved, to a jury. So I think in terms of the methodology of dispute resolution that you would observe in the movies, it's probably correct. Trying cases is hard work. I mean, you really stay up late, come in early, prepare the witnesses, prepare the arguments, the slides. Now you have all kinds of video to prepare on top of it. So you usually have a big team, not just one or two people on a large case. And that all helps because you have on a team, varying capacities, so you don't have to do everything yourself. But when I'm trying a case, I must say there are many times I don't look perfect because you're tired, you're working very hard, and you do the best you can, but my priority then is what I'm going to present to the judge, to the other side, etc.
Thank you very much, Carolyn. And one last question from the audience.
Yeah, thank you, Carolyn. Interesting, impressive meeting with you. My question is, artificial intelligence. What do you think is in the future, let's say 10, 15 years maybe, can artificial intelligence can replace your mission?
It's an interesting question that everyone is struggling with, but my experience so far is it can be a great support to lawyers. Right now, it's not entirely reliable. The results are many times have a bias, and it doesn't really understand everything, but it can help tremendously. If you have a well-developed AI system to use, it can go through volumes of documents very quickly and organize them, by dates, and then actually do searches and organize them by topics, organize them in various ways that are, it saves a tremendous amount of time. The problem is whatever product you get from these systems is not entirely reliable. So it'll give you a place to start, but you then have to yourself go back and look at the Quran, look at the documents, and be sure that they have captured everything the way you would capture it or argue it. So it hasn't evolved to the place where I would turn over even the youngest associate's work to it instead of someone, but you can turn over a good part of it. But then you've got to go through and work on it. Where I've seen it really work well, but again, not unchecked, is on translations. It can give you a translation from Turkish, Russian, whatever languages you're working with, and it's quick. But you still have to have someone who is natively fluent in that language, who knows the legal language, go over the document and make sure that what's translated is correct. But at least it helps you decide whether it's worth reading. So there, I'd say now it has to develop further. And it can, and it will be a great assistance. Do I see it writing briefs in complex cases? Maybe not. Do I see it pulling together a lot of the facts? Yes, but then with a lot of careful checking.
So is it more challenge or opportunity?
I think it provides a tremendous opportunity. I think we all have to be careful because ultimately it's our professional responsibility to check very carefully what it's doing and how it's doing it and how reliable whatever comes out of it is. So you can't assume that because you said write me a letter of X, you're going to get something that's usable. You're going to get a skeleton to work from.
Thank you very much, Carolyn. We really appreciate your answers, and they're very insightful, I would say. And truly, one last question from the audience. They're truly interested.
Thank you. Dear Carolyn, will you zoom in? Hello. Dear Carolyn, thank you for joining us. I'm from administration team of the AFC Court and IAC. So I guess we only have lawyers here, but I'm a financier, and I'm working at the court for 7 years since the foundation. And during 7 years, I'm in love with the lawyers. I'm watching them, I'm supporting them, I'm assisting the case management, everything, excluding the legal work. And very soon I will turn 40. And I'm just thinking, and if you somehow could just help me with that, is it late to start a career as a lawyer at 40? Thank you. Thank you.
I don't think so at all. You bring a great deal of technical skill and wisdom to the task, and at law school would be a limited investment, and so you would be able to provide in a short number of years tremendous assistance to clients. I don't think it's too late.
But as we're raising this question about the challenging for women, women arbitral, etc. So I will prove that I'm worth that. I'm a very young lawyer, although I'm not young. So just to go for that, right?
Why not? Yes.
Thank you so much. Thank you.
Very much. Thank you very much for your questions. Unfortunately, we are running out of time. We are coming to the end of our session. Carolyn, on behalf of everyone here, I would like to address our sincere gratitude for your time and for sharing your experience with us. It is an honor to have a chance to learn from you, and we hope very much to see you again soon. So dear colleagues, let's give Carolyn a round of applause.
Thank you so much. Thank you. It was a pleasure to talk with you.
Thank you very much for your time. Dear colleagues, guests, thank you for your time and thoughtful questions. The next session will start promptly at 3:30 after a coffee break behind the court hearing room, and we hope to see you back soon. Carolyn, thank you very much for your time.